Let me just give it 1 minute to let people trickle in. All right. Welcome everybody to the University of New Mexico Law and Mental Health Didactic Series. This series is hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. We're glad to have you all here joining us today. My name is Julie Bravko. I'm an assistant clinical professor in the Department of Psychiatry and Behavioral Sciences. Next week, we have Ms. Megan Lashak presenting the value of forensic social work. So please tune in for that. For our talk today, please ask your questions in the Q&A anytime you feel comfortable. Just know we're probably not going to get to them until the end. As always, we try to get to as many of your questions as possible, but please forgive me ahead of time if we can't get to yours. For those of you who want CEs but are on a tight schedule, you do have to stay for that full hour today, but you don't have to stay longer than that. So we'll try and let you know when the hour has passed, but just know that we'll probably be staying on longer to address questions. For those of you who are here for CMEs, those are the medical CEs, please go to the link in the chat now. For those of you that want the APA or mental health CEs, you want to wait till the end of the talk. And the last 5 minutes in the chat, we'll post a link to the survey. Please complete it and then save a copy, print a copy, screenshot a copy, whatever you need to do. Just know that we don't send emails out with those. So you want to make sure you grab that for yourself. The recording and PowerPoint for the talk today will be uploaded in about a week. So if you don't see it after a week, then please let us know and we'll see what we can do. The next thing I'd like to share with you is that this is going to be my last week coordinating the series. I remember back in 2018, our first lecture had just a handful of people that we begged to attend. And now 4 years later, we consistently have hundreds of you attending from all over the US and some internationally. This series has been such an honor and pleasure to coordinate, and I want to thank each and every one of you for your support over these years. I especially want to thank all the speakers who have donated their time and willingly said yes to present without making me beg too much. This has been a true highlight of my career this far, and I'm going to miss it, but you will all be in very good hands moving forward, and I look forward to joining you as a participant of this series. Okay, so now it's time for what we've all been waiting for. I'd like to introduce to you our speaker for today, Dr. David Shapiro. Dr. Shapiro is a professor of psychology in the forensic concentration at Nova Southeastern University. He's been involved in forensic work for over 50 years and was one of the founders of the American Board of Forensic Psychology. He has extensive publications in the areas of psychology, law, and professional ethics, including 12 textbooks and over 40 peer-reviewed articles. He's received the Distinguished Contribution Awards from APA Division 42 and from the American Academy of Forensic Psychology. He's lectured both in the United States and abroad on topics involving psychology and law. He's served on the ethics committees of APA, ABPP, as well as state boards. He's also co-authored 2 recent books, Introduction to Forensic Psychology, 2nd edition, and Forensic Practice for the Mental Health Clinician. Dr. Shapiro, thank you so much for supporting our series and for being a repeat presenter for us. On behalf of the University of New Mexico, I'm truly honored to welcome you back, and I want you to know that we're so grateful for your time and expertise today. I'm now going to turn it over to you.
Thank you so much, Julie. As always, it's a pleasure to be here. I look forward to this every time. Okay, Alex, let's move forward with the slides. So I'm going to talk to you about the forensic specialty guidelines. And Dr. Youngren just mentioned to me that these guidelines are due to expire at the end of this year, at the end of 2022. They are to some extent based in the ethics code, which is also currently under revision. So that may pose some sorts of logistical issues. First, the difference between guidelines and ethical standards. This may be old news for some of you, but ethical standards are basically codes of conduct that are enforceable. Guidelines are not enforceable. They are aspirational in nature, sometimes referred to as best practices. The ethics code informs them, and to some extent, as we'll see, they inform parts of the ethics code, but they are distinct. The guidelines are not in and of themselves enforceable, though in some states, actually I'm jumping down to a PowerPoint, to a bullet point below, some states have actually adopted the specialty guidelines as part of the Board of Psychology Code of Conduct, and then it does become enforceable. For instance, Florida, Hawaii, and New Jersey are the ones that come to mind. There may be other states. At this point, I don't know. But basically, the guidelines were designed to cover in-depth forensic issues that were not adequately handled by the APA Code of Ethics. Sections of it were incorporated into the 1992 Code of Ethics. This is why I was saying it sometimes informs the Code of Ethics. There was a section on forensic activities in the 1992 code. And I'm going to make an editorial comment here. Unfortunately, by the time 2002 rolled around and the next version of the ethics code came in, they had eliminated the section dealing with forensic activities. And I still think that was a big mistake, but we could go on and on for quite some time. There was some current concerns about whether or not there would be some conflict between the forensic specialty guidelines and HIPAA, which needed to be explored further. Okay, next slide, please. Okay, so what is forensic psychology? You may think you know what it is, but this is an important distinction. It's an activity of any psychologist when applying scientific, technical, or specialized knowledge. These are statements come directly out of the Federal Rules of Evidence. Knowledge of psychology to the law, and this is the important part, in addressing legal, contractual, and administrative matters. In other words, in doing forensic work, what is covered by the forensic guidelines, there has to be a forensic question, what's sometimes called a psycho-legal question, which you are addressing. Psychology is not forensic solely because it takes place in court, in a tribunal, or in a legislative setting. For instance, a child, say in a nasty custody dispute, has been ordered into treatment, and a clinician provides that treatment. That is not regarded as forensic psychology, unless, and this is an important unless part of the resultant court order is that the clinician do some sort of psychological evaluation, which gets into a whole other ethical issue regarding a possible multiple relationship. Another example that is not forensic, if you are doing clinical treatment, but it's within a correctional setting, that is in and of itself not the practice of forensic psychology. So to put another way, the activity is regarded as forensic from the time the practitioner reasonably expects to, agrees to, or is legally mandated to provide expertise on an explicitly psycho-legal issue. Okay, so it's the idea of definable foreknowledge. So you may ask, well, what happens if the clinician who has no intention of doing a forensic evaluation later gets called into court and is asked to provide some sort of opinion on the forensic issues. We'll talk about that further later, but basically there are limits to what a therapist can say. They can only describe what they have done clinically. They do not have the database to answer the broader questions that might be relevant to the forensic issues. And so all too often, clinicians get called, they receive a subpoena, they panic, they come into court, and they are answering questions that they really have no reason to answer and really should not be answering at all. Okay, next slide. Okay, so this idea of definable knowledge, foreknowledge, is misunderstood. That's pretty obvious from what I just said, by psychologists and unfortunately by licensing boards as well. I have been involved in a number of cases as a witness on behalf of a psychologist who had charges filed against them. And in at least 3 cases that are fairly recent cases, it was based on the fact that the licensing board, and in fact, the expert witness hired by the licensing board, was negative toward the psychologist, saying that, well, the fact that they wrote a letter to the judge makes it forensic in nature. No, it doesn't. If the judge asks for a progress report about therapy, that is not a forensic activity. A forensic activity is doing a psychological evaluation and answering certain psycholegal questions. Okay, and this has happened on any number of occasions, which we don't have time to go into at this point. So the guidelines, again, are advisory. They don't supplant clinical judgment. They provide only general or conceptual guidance. This is an important point also. Unless it is part of the state law, as I mentioned before, it is not regarded as a standard of care for disciplinary actions, does not provide the basis for civil or criminal liability. Again, it may be part of the data that is cited in these cases, but it is not in and of itself a basis for these findings. I think I mentioned this before, aspirational, which the guidelines are, represent the highest level of practice. They are not, therefore, enforceable. In practical terms, though, if you, in some way, you as a clinician, or you as doing a forensic evaluation, don't adhere to the guidelines, you can well get a cross-examination question about the guidelines. You say, well, those are aspirational. I just go by the ethics code. Oh, doctor, then you're saying that you don't believe in practicing at the highest level of professional practice. So it can be kind of tricky. Okay, Alex, next, please. So let me talk about specific parts of the forensic specialty guidelines. One of the big ones is integrity. It sounds great, but what is integrity as far as this is concerned? Resisting partisan pressures to provide services in any way that might be misleading or inaccurate. I give the example of test adjustment. So in other words, and I'll talk about this in a moment, in a forensic setting, inevitably, unless you are just a court-appointed witness that is agreed upon by both sides, anytime there are 2 sides to a case, plaintiff and defense or defense and prosecution, there is going to be pressure on you. Each side, wants you to find something that would be helpful to them. Or if you're retained by one side to concede on cross-examination the other side. You, as a forensic psychologist, have to resist partisan pressure to provide services in any way that are misleading or inaccurate. Many years ago, I was involved in a case where a psychologist was using the MMPI. I think it was way back when it was the original MMPI, to determine whether or not someone was lying when they said that they had not abused a child. What did the psychologist do? He looked at the L scale, sometimes called the lie scale on the MMPI, and said that an elevated score on the L scale meant that they were lying when they said that they had not sexually abused a child. That is clearly misleading, inaccurate, and just plain unethical. There's nothing in an MMPI interpretation that tells you whether or not a person is lying or not. In a similar manner, people use tests in ways that they were not intended to be used, in a way in which they have not been validated, on a population on which they haven't been validated. Perhaps the most disturbing aspect of this is a recent controversy regarding ethnic adjustment of IQ scores. Most of you are probably aware that in 2002, the United States Supreme Court ruled that it was a violation of the Eighth Amendment to execute people who were mentally retarded. Of course, that has since been replaced with the term intellectually disabled. But at any rate, unconstitutional. And they left up to individual states, the Supreme Court left up to individual states to determine what the definition of mental retardation was. Most states adopted the DSM diagnosis of mental retardation, namely substantially sub-average intellectual functioning, substantial impairment in adaptive functioning, and onset before the age of 18. Well, some folks decided to take it upon themselves to capitalize on an observation that has frequently been seen, which is that these IQ tests, primarily the Wechsler, may tend to, the score that you get on the Wechsler may not represent the person's full level of intellectual functioning. So these folks arbitrarily added a certain number of points. And the number of points they added was due to what they called their clinical judgment. In other words, there was no science behind it. And in reviewing the various cases across the country, I found that these ethnic adjustments went anywhere from 5 to 17 points upward. So they would say, well, based on my clinical judgment, this person is really functioning 17 points higher than the IQ. And guess what, folks? That took a lot of these people out of the range of mental retardation, placed them in either borderline or low average. And by golly, then the state was able to execute them. So you can see the damage that could be done and was in fact done. One psychologist was in fact disciplined by his state board of psychology for doing these ethnic adjustments of IQ scores. The amazing thing from the point of view of psychology, not only that he did it, but that he got it published in a forensic journal. So much for peer review. Anyway, I could go on and about that. And in fact, I've written an article that captures all of my outrage about ethnic adjustment of IQ scores. Okay, Another major principle, impartiality. You have to keep an open mind about a particular evaluation that you're doing. And the specialty guidelines say that you need to weigh all data, all opinions, and all plausible competing rival hypotheses. Actively seek them out. Avoid partisan presentation of incomplete or inaccurate data that could mislead triers of fact. In other words, not doing some part of the evaluation that would be standard forensic practice, not doing it because, well, you think it's really not important, and coming up with a really incomplete kind of conclusion. Now, this does not keep you from advocating for your opinion. Once you have collected all the data, there's nothing that stops you from forceful presentation of the data. You are not at that point advocating on behalf of one side or the other, say the prosecution or the defense. You are advocating for your data. So the idea is that you have to be as objective as possible, gather all sources of data that you can during the data collection phase. Once that leads you to reach a conclusion, you can feel free to present that conclusion as forcefully as you want. As long as there was no bias in the data collection. There was the joke that a judge, in fact, once made, that he said that he wished he would have a one-handed psychologist in testifying in court, because he's so sick of hearing on the one hand this, on the other hand that. Okay, so you have to include evidence from all perspectives. You have to avoid conflict of interests. Seek input. Sometimes you're not aware that there would be a conflict of interests. If there is, of course, the best thing is to avoid it. But you can, if you think it is manageable, after you reveal the conflict to all parties, and you honestly believe that your decision-making would not be affected by your previous involvement with one or another one of the parties, you can proceed. You need to document, of course, the fact that your decision-making is not affected, but then again, they may try to expose it on cross-examination. So if you actively seek out these sources of information, you find out that there is a conflict, best to avoid it. Okay. Next slide, please, Alex. Okay, there is a section on in the specialty guidelines, as there is in the ethics code, dealing with competence. And this is really what is defined as competence, both in the ethics code and in the specialty guidelines, are consistent with the federal rules of evidence. Originally came out in 1975, was revised in 2000, 2011, 2016. And it basically said, this was the definition of an expert, that you can claim expertise if you have sufficient knowledge, skill, experience, education, and training in a particular area. And while there's some variation in the wording, that's basically also what the definition in the ethics code of competence is. Essentially, knowledge, skill, education, experience, and training. Now, you may say, so what? How does this help you? Well, for me, it provides a helpful heuristic. You will find yourself in your forensic practice getting referrals where you're not so sure you really have the expertise to take this on. So I find it helpful to ask myself, would I feel comfortable offering testimony about this and being cross-examined on this material? Do I feel I have enough expertise to deal with? If not, I will definitely refer to someone else. Obviously, maintaining competence, within the ethics code, of course, it talks about keeping up with scientific and professional developments, but you also need to keep up with psycho-legal developments. Like, for instance, what are the criteria for admissibility of expert testimony? They may have changed since the time you started doing your work. You need to also recognize legal and professional standards. Let's say, for instance, you have a client or somebody that you're doing a forensic evaluation of who says, I don't want to participate in your examination. Okay, you cannot proceed with that examination. You can't make believe that you have seen them or base your evaluation just on collateral data, without actually seeing them. So they have a right to basically refuse, in which case you will notify the court or their attorney that they've refused to participate in the evaluation. And that's where your involvement stops. You can't make conclusions about somebody who has refused to participate. You have to know the scientific basis for your opinions and testimony. What are the limits of knowledge? And you should take an affirmative stance, informing the referral sources when they ask you to do something that that there is no scientific basis for. One of the most frequent referrals that I have gotten in the past, less so now because I have retired from active practice, but doctor, I have a client who is charged with sexually abusing his son. Would you please examine him? And so I can present a defense that he doesn't fit the psychological profile of a child molester, of a pedophile. Okay, you have got to know the scientific literature. Say there is no such thing as the psychological profile of a child molester, or the psychological profile of a murderer, or the psychological profile of any kind of sex offender. There's just no such thing. And you need to inform the referral service, party, person who's called you, that that's a question that cannot be answered. Now, they may go and then find somebody who's willing to testify to that. Well, nothing you can really do about that. Obviously, you want to consider the impact of your personal beliefs, and if they are, if they would get in the way of your objectivity, you will best to decline participation. It says you can correct or limit it, but that is very difficult. Again, appreciate individual and cultural differences. That doesn't mean taking a weekend workshop in multicultural psychology, but do make referrals if necessary. And even if you have done all these things, guard against the misuse of your services. I had one case a good number of years ago. I had done a psychological evaluation, wasn't particularly helpful to the attorney. It was a defense attorney who had hired me. And that was it as far as I knew. The next thing I heard was that the defense attorney had in fact used my report, but had edited my report to leave out things that were not helpful for his opinion, for the opinion that he wanted provided in court. And this is a tricky kind of situation, because attorney-client privilege, it was not I did not have an opinion that was helpful to the attorney. So that had to be kept, that was privileged information. My evaluation was under the umbrella of attorney-client privilege. And I certainly couldn't call up the prosecutor and say, hey, you know what this defense attorney is doing? Couldn't do that. So you just have to sit with it. But this will happen, that people will try to misuse your services. Try your best to avoid that. Okay, next slide, please. Diligence. Well, of course, we all know we have to be diligent, but what is really included? An explicit agreement regarding the scope of what you're doing, the time frame, what compensation will be coming, and that discretion about services that are needed. Okay, so you will tell them what your evaluation normally involves, what the expected time frame is, what compensation, either you get a retainer, or what your hourly fee is, when you're not allowed to ask for a retainer. Discretion about needed services. Attorneys have taken it on themselves, not all attorneys, but many attorneys, and they will tell you what tests to give and what tests, more importantly, not to give. They say, don't give a Rorschach because that's not a valid test. They really don't understand what validity and reliability are all about, or how the results of a Rorschach would not be used by themselves, but only as one piece of data, and that you're looking at consistency across different data sources. They'll tell you not to use an MMPI or a PAI, because they have scales on them that measure antisocial potential. And they don't want a judge or a jury to hear about the fact that the person tests high on the antisocial scales. You need to make it clear that it is your professional discretion that determines what kinds of evaluations you are going to give and not give, that they're not in a position to tell you what to do and what not to do. Now, this sometimes gets outside of testing. This sometimes gets to attorneys refusing to provide you with certain information, certain collateral data. This has happened to me a number of times. Now, of course, you ask the attorney who has retained you for all of the collateral material that is available. And they may choose to withhold certain things. I had a case of several years ago, one woman who had killed her abusive boyfriend. It came out in discovery that she had kept a daily diary. And the diary, the prosecutor had the diary. It was seized during when the police arrested her. And of course, the defense attorney had the diary as well. I asked for the diary. Defense attorney said, no, I'm not going to give it to you. Why? It might have something in it that might negatively impact on your opinion. I said, look, that's my role as a psychologist, forensic psychologist. I look at everything objectively. We are going to be compromising your case if it comes out on cross-examination that there was an important piece of data there that I failed to review. Still refused to give it to me. And that's exactly what happened. Is on cross-examination, prosecutor asked me, had I reviewed the diary? Answer, no. And doctor, why have you not? Because defense counsel refused to give it to me. Okay, you have to be honest about your opinion. If there are any changes in the time frame, the scope, the compensation, make sure that the clients, in this case, client being the referral source, knows about the changes. I mentioned before, I think, about trying to avoid multiple relationships in forensic practice. In other words, do not be a clinician and a forensic evaluator in the same case. There are basically three reasons for this. One is that it's a different kind of relationship. In the therapy relationship, you are in a therapeutic alliance, you're trying to help this individual. A forensic evaluation is not like that. You're supposed to be an impartial, objective evaluator. As a result of that difference in relationship, the methodology is different. A psychotherapist will very rarely seek out extensive collateral data, where a forensic evaluator will. That's part of the process of forensic evaluation, to get a variety of data sources, including collateral data. Rarely is a therapist going to do extensive psychological testing, especially testing that deals with the possibility of malingering. Well, in forensic settings, that's something that you must do, because the question of malingering almost always comes up. So this gets to the point which I touched on before. Can therapists testify? Yes, but only within limits, based on the data that they have as a clinician. They can testify about their diagnosis, their prognosis, their treatment plan. They can talk about their progress notes, but they cannot address any forensic issues. In fees, you charge a fee that is commensurate with your extent of experience. Make clear, most often in a forensic case, you want to have the referral source pay your fee. You will get frequently attorneys say, no, contact my client, they'll pay your fee. That puts you in a very difficult position. Or could, it would have the appearance anyway that, you are testifying on behalf of that patient rather than doing an objective evaluation if they're the ones writing you the check. For the same reason, avoid contingent fees. I assume you all know what a contingent fee is. That is where you take a fixed percentage of the ultimate settlement. The traditional is that the client receives a third, the lawyer receives a third, and you receive a third. Don't do it. Why? Because that could be seen, or at least have the appearance of influencing your objectivity. If you find a person more disturbed than they actually are, that could result in a higher settlement and consequently a higher fee for you. So some people try to avoid this with what is called a letter of protection, where you make sure that your fee is going to be paid in full, regardless of the outcome. I don't have any problem with this. Some people see it as just another way of a contingent fee. It can be if the lawyer writes the letter. If you choose to use a letter of protection, you write the letter of protection and have the attorney sign it. So you say, that my fee will be paid in full, regardless of the outcome of the case. I had a case that I call my $2,000 mistake. Boy, do I learn from these mistakes. The attorney wrote it and said, your fee will be paid in full from the proceeds of the case. Not to bore you with the details of the case, but the plaintiff was actually such an obnoxious character, aggressive, abrasive, the jury hated him. And so even though he had a slam dunk case, they awarded the defendant. They found in favor of the defendant. There were no proceeds of the case. I didn't get 1 red cent for my efforts. So if you're going to use letters of protection, make sure you write them. Okay, next slide, please, Alex. Okay, informed consent. Informed consent legally has 3 elements, okay? Sufficiency of information, competence, and voluntariness. I don't want to go into detail again in terms of the time, but sufficiency of information means you provide enough information to the person that you are evaluating so that they can make an autonomous choice whether or not they want to participate. That's sufficiency of information. Sufficiency of information also includes any limits of confidentiality that may exist, or, under what circumstances the attorney-client privilege may be waived, may be foregone. Who will see the report? Who will have access to the data? All of that is part of sufficiency of information. You then ask the person to say, the person you're examining in their own words, what it is you just told them. And if they've got the basic understanding, they don't have to have a very sophisticated understanding, basic understanding of what it is you told them, and especially what the limits of confidentiality are, then you can proceed, assuming the 3rd element, voluntariness. Now, given what we have just discussed, do I have your consent to go ahead with this evaluation? Yes, then they have satisfied the 3rd element. Do not examine them if they do not yet have an attorney. Okay. Okay, next slide, please. Okay, and this is just, I'm going to say this will be the last thing, and I'm touching on something that I know that is quite close to Dr. Youngren. There had been, the Code of Ethics changed dramatically. Early on, it said that when you have a conflict with the, if your Code of Ethics conflicts with some sort of legal authority, you try to work it out in a reasonable and appropriate manner. Unfortunately, this was in the 1992 Code of Ethics. Unfortunately, it never told you what the details of that were, or what would happen if you were not able to work it out in a reasonable manner. In 2002, the code added, basically addressing this point, what happens if they don't, if the legal authority demands data. And by the way, this was all within the context of revealing of psychological data, revealing of confidential information within the record. This is what this addressed. And it So it basically said, if you've tried all of these reasonable steps, you documented them, and the court still refuses to go along with them, then you can follow a legally binding order without fear of ethical sanctions. Okay, I think that provided great guidance, helpful guidance anyway. What happened within the next, 10 years or so, is that the group that became concerned about the fact that APA was sanctioning torture of enemy combatants saw this part of the ethics code as sanctioning, and in fact, as being written in order to give what they called wiggle room to psychologists who wanted to involve themselves in torture. In other words, they could say, I know it's unethical, but I was ordered to do it, so I had to follow orders. Well, this would be presumably military psychologists. Well, just a few things before I finish up. First of all, as I said, that phrase about being able to follow a lawful court order applied to psychological records, nothing else. Despite the assertion by many people, and in fact in a book by a New York Times author, that the ethics code was changed in order to accommodate torture, that has absolutely nothing to do with that change. But this group was so powerful that they succeeded in getting that phrase, following a lawful court order without fear of ethical sanction, removed from the next version of the ethics code, which came out in 2010. Actually, it wasn't a whole new code. It was just a statement, a statement that dealt with that. So they took out the idea of following a lawful court order, and they just substituted, you work it out in a reasonable manner, but under no circumstances can this involve a violation of basic human rights. The other thing that's important to note is no military psychologists were ever involved in torture. The psychologists who became involved in these torture protocols were independent contractors who got paid very well by the Department of Defense for developing their torture programs. And they were not military psychologists. So this is a very distorted view. Now, how does this relate to the specialty guidelines? Specialty guidelines addresses this very thing, but allows the following of a lawful court order, but just adds, provided the court order does not result in the violation of any basic human rights. And I think that that's an excellent model for the new Code of Ethics, which, as I mentioned before, is currently under revision. Okay, folks, that is about it. I got some time for questions. So, Julie, fire away.
Thank you so much. First question, would you comment on strategies when a psychologist uncovers unethical behavior by an opposing psychologist in a case that has not yet been resolved, and then also after the resolution?
Great question. The idea of filing an ethics complaint under those circumstances, or a licensing board complaint, is very ill-advised, because it can be seen as sour grapes, especially if the person is an opposing expert witness. It can be seen as limiting or compromising your objectivity. On the other hand, if the case has been fully resolved, and that is a sticky question because cases are very rarely fully resolved, especially if you're doing a case in family court, because custodial and visitation arrangements can always be revisited. But the same cautions really do not apply after the fact. Another reason, the ethics code says that before filing any complaints, you try to work it out informally with the person involved. Well, if that person happens to be another expert witness in the same case, you can be accused of witness tampering, and that is a felony. So you definitely do not want to do it before the case is resolved. Okay.
Thank you. The next question is, how do we justify informed consent with evaluees who are actively experiencing symptoms like psychosis or mania and seem to be out of touch with reality? Even if they say yes, they may have no idea what's going on.
Great question. It's your clinical judgment as to whether they remember the three elements. They have to be competent to understand what you're talking about, competent to understand the limits of confidentiality. So all of these elements, the sufficiency of information, the competence and the voluntariness all go together. So if it is your clinical judgment that this person is not competent to give informed consent. Now, if you've been hired by the defense attorney, you can get in touch with the defense attorney. Defense attorney under the law can give what is called substitute judgment. They can consent on behalf of the client. Okay. If you've been hired by the prosecution, you can't get substitute judgment from a prosecutor. There, you just have to, probably through the lawyer, who would, probably through the prosecutor, if you've been hired by the prosecutor, just notify the court that you are unable to obtain a fully informed consent from the person to the evaluation, in which case the court may just order the person to participate in the evaluation. Even then, while you can't get consent, you can get what is called assent, which means they agree to go along with it, even though they do not fully understand the parameters of it. So yeah, it's always your clinical judgment, but you do have those options. And of course, if it's court ordered, you would notify the court. You would say, Your Honor, I've been asked to do this evaluation, and this person is so psychotic that they are not competent to give an informed consent to the evaluation. Great question. Yeah.
Okay. Oh, this next question hits home for me. I've talked to Dr. Youngren about this a few times. How do you handle situations in which opposing attorneys or judges tell you how long you have to conduct evaluations and under what circumstances they can be conducted when it may differ from being able to follow the guidelines?
Obviously, you have to follow the court order. And then you just indicate, you're allowed ethically or encouraged ethically to indicate any limitations regarding validity and reliability that you have, in which case you don't have to say the judge refused, but you just say, this is based on the data that I had during the time frame that I was given to conduct this, and I have not been able to do the following tests or do the following evaluations or consult the following data, and you just qualify your conclusion in light of the missing data.
Next question. What are your views about providing feedback to examinees following the completion of a forensic mental health assessment?
Yeah, now generally, ethically, you're supposed to provide it to them. And I'll say I differ somewhat with a number of other practitioners who will do the same in a clinical evaluation or in a forensic evaluation. In a forensic evaluation, you don't always know how the data is going to be used. And for that reason, the first person I will communicate the data to is the attorney, and then find out from the attorney as to whether or not it's okay for me to meet with the client, assuming the examinee, to be more precise. Yeah, is it okay for me to then meet with them and provide feedback? But I would always check with the retaining party first.
Okay. Next individual says, you mentioned there's no testing or profile for an offender, like sex offender or murderer, for example. This individual is curious about your thoughts regarding testimony on child sex abuse victims. They often see prosecution experts testify on what an abused child looks like. For example, they often delay, or they might do XYZ behavior. And it seems that in such an expert opinion, that expert is actually giving judgment on whether this child fits a typical profile of an abused child.
Exactly. And you just have to be very, very careful under those circumstances for exactly that reason, because one of the things you have to avoid as a forensic expert is testifying to what is called the ultimate legal issue. Did this thing actually occur or not? That is not your role as an expert, as a psychological expert, as a forensic expert. You say that these are the characteristics of, what the literature says about, the characteristics of a sexually abused child. And by the way, it is better under those circumstances for you to present that as an expert just on the science. You should not also be examining the child, because then they'll say, well, you're saying, doctor, that this is the profile from the literature. Now, does this child fit the profile? You want to avoid that kind of thing. That is a decision for the court to make. So you can come in and make it clear to the attorney if you want an opinion on what abused children tend to look like, and they can look like many things, but here's what you come in as an expert on the science, on the literature, not as an examining expert.
Everyone, we're about 1 minute away from the hour, so if you have to jump off, make sure you grab the CE survey and save yourself a copy of it. Dr. Shapiro, you're okay staying on a little bit longer to answer more questions?
Sure.
Okay, great. All right, here's the next one. Can you please expand upon the status of the ethics code in place at the time of the contract, psychologists who assisted in the torture tactics? In other words, can you delineate how APA was not complicit?
How APA would what?
Was not complicit.
Oh, that's a loaded one. It would take much more than a basic response. I would go at it the other way. I don't see any compelling evidence that they were, and that the psychologists involved, as I said before, were independent contractors. Only one of the two was in fact an APA member. The other surrendered his APA membership when it became clear that some ethical issues were involved. So there really wasn't very much that APA could do in terms of these people. The other, and again, the other thing is I can't say reasons that they're not complicit, but I don't see any compelling evidence that they were.
Next question, can you speak to any points of authority or experience with supplementing your evaluation after the initial evaluation and report has been submitted to the referral source? Like, for example, if you find additional data that might be helpful to conceptualizing the case.
Oh, sure, I have no problem with that. And as a matter of fact, I will, especially if there's certain data that I know is out there that I haven't been able to get access to, I will always put in my report, this is based on the data that I have available at this time, and that if further information becomes available, I'll be glad to supplement the report.
Do you have any suggestions on how to respond to a judge ordering the administration of a specific psychological test, besides explaining the rationale for how a test is selected?
I think you would have to go through the attorney. You know, if you have, you know, if there's no problem with it, fine. But if you have a problem with that particular kind of assessment being used, you feel it is out of date, it has problems with validity, it has been normed on a different population, you would have the attorney ask for a hearing on that issue, you know, and you would present the information. If the judge says, I don't care, I want you to do the evaluation, of course, you then have two options. You can refuse to do the evaluation, or you can do it and then qualify your results. I haven't encountered a situation like that, but on the other hand, if I had one like that, I would just say, I'm not going to do the evaluation. Now, of course, if it led to being found in contempt of court, I might not go that far. There's a famous case not involving forensic evaluation where a psychiatrist refused to go along with the judge, and he wound up spending overnight in jail. I'm not so sure I would go to that point.
I'm not so sure I would either. Okay, how do you handle it when the opposing side's expert is the longtime therapist of the examinee, and they likely don't have any actual forensic experience? Would you educate retaining counsel about this issue, or does that put you at risk of multiple?
Oh, no,
roles
definitely.
Okay.
You know, that is something that you would want to discuss, you know, and that they will incorporate into their cross-examination, you know, that is a multiple relationship that is unwise, that the person does not have the data to render their conclusion. That, by the way, raises another tricky kind of issue because there are some folks, and I've seen this on forensic listserv recently, that say you should not take both roles, you know, that you should not in any way be an advocate and an expert witness. I disagree with that. I think that if you see somebody else doing something which you believe is unethical, you can, through the attorney, you know, expose it. And even if you don't raise the issue of ethics, say it would compromise the objectivity of their opinions.
Okay. Regarding the misuse of one's product, in forensic family court work, it's generally the practice that litigants may review the report as frequently as they wish, but they're not to possess a copy as a condition of retention as a protection against misuse. However, they're typically legally entitled to possess a copy, and once that's the case, the psychologist may be unable to protect against misuse. What's the proper stance for the psychologist to take?
Well, first, I was unaware of the fact, that they can, that they do that, although it does make sense. I would suggest that rather than just providing them a copy, you go over the findings with them, and preferably with an attorney present, so that there's a record made of what was said, what was not said, what the correct interpretation of the data was, things of that sort. Okay.
All right, this next individual is employed by an agency that's contracted to provide mental health services in a correctional facility.
Okay.
And they're wondering if the diagnostic evaluation, post-conviction but pre-sentencing eval, or intake evaluations are considered forensic. They said they generally never did, but they are used in the court system.
Well, it gets back to the definition of forensic. Are there specific psycho-legal issues involved? And is there definable foreknowledge that they will be used that way? Generally, these are, used internally, like to determine placement, like what degree of security this person needs. So I personally am unaware. When I worked with corrections, the decision, of, say, one of these intake evaluations did not get shared with the court. If it did, then again, is there a forensic issue related, such as risk assessment? In that case, it probably would be forensic if you're going to express an opinion on risk assessment or on anything that might have, some implications beyond just being within the correctional setting itself. But consistent with this person's question, it generally, these reports, in my experience, these reports are just used internally. They're usually not reviewed by the court.
Right, right.
I got time for one more question, Julie.
Okay. In the context of competency to stand trial evaluations, many evaluees are going to be cognitively and psychiatrically limited.
Right.
If the eval is court ordered to begin with, is it acceptable to continue if the defendant does not seem fully competent to consent to the interview?
No. You really do not want to do that. You send a report at that point saying that at the present time they do not appear to be competent. You might recommend, what sort of treatment, what sort of hospitalization would be necessary. And generally the court will ask for a reevaluation after a certain number of months or a certain number of months of treatment.
All right. Thank you so much.
Oh,
This
you're
was
very welcome.
fantastic.
It's been my pleasure. And these are some very, very stimulating questions. I've enjoyed them.
Thank you. You have a great day. And again, we
Okay.
really appreciate your time.
Thank you. Always
to
a
see you.
pleasure. Okay.
All right.
Bye.
Bye.